The next matter to come before the court this morning is William Besancon et al. Versus Cedar Lake Farms Corporation et al. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. I know that there is a cross appeal in this case, but the cross appellant needs to address both the case and the cross appeal in the 15 minutes allotted, and it's not have the opportunity to reserve any time for rebuttal. Your arguments are being recorded this morning and will be placed on the court's YouTube channel. I don't think it's relevant, but we like to always make the advisement not to use the name of children or victims, as I just indicated, this argument we posted online. Please stay behind the podium and introduce yourself to both system counsel, but it's a good idea to reiterate that before we begin oral arguments. The judges have read your briefs, and we are ready to proceed if you are. Would you like to reserve any time for rebuttal?
Yes, Your Honor. The appellants would reserve 3 minutes.
Certainly. Thank you.
May it please the court, my name is Tim Pederini from the law firm of Retzel & Andrews. I represent the appellants William and Sandra Besancon. This case is a matter on appeal from the trial court's dismissal of the Besancon's complaint based upon appellee Cedar Lane and Thomas McNamara's motion to dismiss. The trial court held that the Besancon's complaint must be dismissed because it's barred by a prior June 3rd, 2019 settlement agreement between the Besancons and Cedar Lane. The trial court's judgment was an error and must be reversed because the settlement agreement does not bar the Besancon's complaint, Besancon's claims, and thus their complaint states a claim upon which relief could be granted. The complaint stated 4 counts. The first was a breach of contract. The breach of contract dealt with a lease that had started in 1986. The lease contained, at the time, 32 greenhouses, eventually 40 greenhouses on the Besancon's property, actually the Besancon's, Williams Besancon's parents' property. The second claim was for fraudulent inducement for Cedar Lane and McNamara's intentional concealment of damages to the leased property, to the greenhouse, and the receipt of insurance proceeds of over $722,000. This was concealed and it was induced the Besancons to enter the settlement agreement. This is pled in the alternative to the breach of contract claim. The third claim was piercing the corporate veil against Cedar Lane to bring claims against Mr. McNamara directly and personally. And the fourth claim, again, was in the alternative as an unjust enrichment claim based on the receipt of these insurance claims of over $700,000 and failing to repair the damages that resulted in the payment of those insurance claims. All of the counts of the Besancon's claims of the complaint, state claims, upon which relief could be granted, and the trial court's judgment was an error. The first assignment of error is the dismissal of the complaint, which we believe was reversible error. I want to talk first about the first cause of action, which is the breach of contract. As I mentioned, this would involve a lease of real property. The property consisted of greenhouses. The Besancons, the predecessors to the Besancons, ran the greenhouse business prior to Cedar Lane and Mr. McNamara taking over this. What was later learned was that there was extensive and essentially, as the complaint alleges, damages that made the greenhouses irreparable in essence. They need to be destroyed, as the complaint indicates. And I should mention at the outset, all of the facts of this case are in the complaint. All the facts I will talk about are in the complaint. And because this is a motion to dismiss, all of those facts, of course, as the court is aware, are accepted as true. The standard for, of course, a motion to dismiss, as the court is also aware, is it must appear beyond the doubt from the complaint that the plaintiff can prove no set of facts entitling him to recovery. Certainly on the breach of contract, that's not the case. The court ruled not that there was some type of default on this breach of contract or some type of faulty pleading in the breach of contract, but that there was a prior settlement, and that settlement somehow barred the breach of contract claim. The settlement did not relate directly to the greenhouses at issue or the lease at issue. It related to an adjacent property that was unrelated to that. However, and that was litigation. The settlement came as a result of litigation between the parties. The settlement, however, had this very broad release of all claims. Not probably coincidentally, the effective date of the settlement was June 3rd, 2019. 3 days prior to that, Cedar Lane and Mr. McNamara received over $300,000 of insurance proceeds. It is beyond doubt that and again, the facts are what they are in the complaint. The damage, the money was never disclosed to the Besancons that he received this insurance money. And it is also not in dispute that none of the repairs were made that alleged, that resulted in these insurance proceeds. So the court looked at this, said, hey, there's a release of all claims, the insurance monies, and there was actually 5 years prior, in 2015, there was another claim for insurance proceeds of over $400,000. The court said, look, those insurance proceeds, those claims were made prior to the settlement, there's a release, and therefore the complaint is dismissed. That's wrong on several fronts. First, you have to look to the lease and the language of the lease. The lease provides that Cedar Lane is to maintain the leased buildings and premises in a good state of repair, reasonable wear and tear accepted. This language means that it's not a breach when damage occurs. It's a breach if damage occurs and you don't maintain or repair the premises. Clearly there was damage, and that damage occurred prior to the settlement. It also occurred after the settlement, as we later know from Mr. McNamara's testimony that's on record in this case. But the duty and the breach that we've alleged is that it was not repairing the place, not repairing the greenhouses and the rental property. That is the breach, not the damage itself. The tenant in this case, Cedar Lane, would have up until the end of the term to make these repairs. And it's just common sense. He didn't receive the proceeds. He received the proceeds 3 days before the effective date of the settlement. There's certainly the extent of these damages to the greenhouse couldn't be repaired in that short of time. And again, you know, damages occur to the premises. It's not the breach. The breach is not alleged as the damage. The breach is failing to remediate or to repair them, as the complaint alleges and as the lease states. The lease also says that there cannot be waste that is committed. Again, if there is waste of the rental property, the tenant would have, in this case Cedar Lane, the entire lease term to repair or to remediate that type of waste. So that claim could not even be brought until the end of the lease term. That's why the breach of contract, count 1, certainly states a claim for which relief could be granted. The second claim is fraudulent inducement. It has been alleged that the Besancons would not have entered a settlement agreement with such a broad release if, in fact, they had known that the damages to the greenhouse and to the rented property that they own had been so extensive, and certainly would not have entered into a settlement agreement with such broad release language if there had been insurance proceeds paid in the amounts that they had been paid, especially just prior to the settlement agreement being entered into.
Counsel, when I was reading this, I was just thinking about, doesn't a landlord have some duty to inspect and keep apprised of the condition of the property?
They certainly would have the ability to do that. Do they have the obligation or the requirement to do that? Not under these lease terms. They certainly would not. And again, it's difficult, as the complaint alleges, these are greenhouses. And the extent of the damages are not readily apparent. That became later into, which is a record in the motion for relief from judgment, that these damages are difficult to ascertain because the broad scope or the real money in this is all the scaffolding that needs to be, that is required to make any of the repairs in a greenhouse.
Counsel, with respect to that issue though about individuals' responsibilities and requirements, is the original lease in conflict with the amended lease agreement? It seems to me from reading the briefs there were different terms in the second amended lease agreement than were in the original lease.
There are, certainly, there's an amendment to the original lease.
Yes,
okay.
that's, yes.
And the amendment does nothing to, in fact, negate the original lease. It doesn't negate the fact that you have to maintain and repair the premises. It doesn't negate the fact that you can't commit waste of the premises. There are additional terms in the settlement or in the amendment that deal with the transfer of some personal property, and whether these greenhouses are actually personal property is again maybe something that would get litigated if this case ever moved beyond the motion to dismiss state of where the case was dismissed. But the main allegations of the complaint of waste, failure to repair, failure to maintain were not amended out of the obligations, the original obligation from 1986. And again, what's most importantly, it's really Section G of that amendment is what is briefed by the appellees. They are claiming that, hey, we could transfer these to you, these greenhouses or whatever the case may be, and you accept them as is where it is. Well, two things. One is they vacated the premises and they weren't in possession at the time of the end of the lease, so that negates that clause. Secondly, there was no transfer, there was no bill of sale that ever occurred. 6 months after, there's like a sunset clause on that. 6 months after, if they don't come back, they don't take anything that could be considered personal property, it becomes the ownership of the landlord, in this case the Besancons. So we do believe that the allegations of breach of the contract are consistent with the amendment, and those were not amended with the amendment that you're referring to, Judge Hensley.
Thank you.
Again, going back to fraudulent inducement very quickly, all of the elements of fraudulent inducement have been properly pled and alleged in the facts of the complaint. It seems to be that the trial court and the appellee's argument is that because the consideration wasn't returned, that somehow a fraudulent inducement claim fails. Here, the settlement agreement had two components. The first component was the exchange of goods. Essentially, some items were going to the Besancons in exchange for $66,000. That was part one, and that was in cash and rent forgiveness. That was part one. The second was the dismissal of the action that was filed by Cedar Lanes in exchange for the release. So there was nothing to give back for the fraudulent inducement claim to proceed. It was simply a dismissal of the complaint. Again, very typical in the settlement agreement. This case is dismissed, and everyone releases claims. In this case, the dismissal was they're alleging that the release was very broad. The release, however, did specifically reserve to both parties the ability to file suit on anything that happens in the future. That is, again, what happened here. These obligations, the obligation to maintain, the obligation to repair, and to not commit waste, go all the way until the end of the lease. That's what didn't happen here.
And Counselor, just now reaching that rebuttal time, you may reserve or continue as you see fit.
Okay. Very briefly on the attorney fees issue. The attorney fees, there was a motion. The court heard evidence, heard the amount of attorney fees. The judge made two rulings. One is that there was not frivolous conduct or any type of 23-2351 violation of filing this complaint. And secondly, he had some type of judgment that said attorney fees are granted on the settlement agreement. However, I lost jurisdiction to make such a ruling, or he believed that. So it's a very strange argument. One, we would contend the complaint was not dismissed, so attorney fees are not warranted on that basis. Secondly, is that the motion to enforce the settlement, that was not before the court. There was no counterclaim. There was no argument, frankly, that these compensatory damages related to the settlement agreement was before the court. So any type of attorney fee award or any type of judgment related to attorney fees, we believe was an error, and that would also address, I guess, the cross appeal as well. Thank you.
Thank you, Counsel.
May it please the court. My name is Doug Gershaw, counsel for Cedar Lane Farms and Thomas Lockhart. With me is my colleague Amanda Weber. looking first at the Besancon's appeal of the fundamental dismissal of the case, to find in their favor on that issue would be to throw out the law of Ohio on releases. It would eviscerate the law. If you look at page 2 of their brief, they admit, I will read from the bottom of page 2 of their brief, they say the crux of Besancon's complaint is that their claims arose after the date of the settlement agreement because Cedar Lane had until the expiration of the lease to repair the damages to the greenhouses. You can always do something after a settlement agreement that would have fixed, so to speak, the problems the settlement agreement was supposed to have resolved. That doesn't mean you didn't have a settlement agreement. It doesn't mean you didn't have a mutual release. They have admitted that the damage in question that they're complaining about happened before the settlement agreement. The money that they're claiming that was received was before the settlement agreement. Everything relevant was before the settlement agreement. The fact that something else could have happened to remedy the situation afterwards doesn't take it out of the terms of the settlement agreement.
How do you make that determination though on a motion to dismiss?
Because the settlement agreement was a part of the record that is permitted to be considered.
And it was attached to?
I forget if it was attached to Tim's complaint, but it was attached to our motion to dismiss, and the law allows that as a matter of considering a motion to dismiss.
Right, okay, but how do you get around the fact that in looking at that settlement agreement, they're alleging in the complaint, in the factual allegations, that this conduct or this action, whatever the damages were committed after the settlement agreement?
No, they're not alleging that. They're admitting it happened before.
Well, you just
They're
said
alleging
you
they
said
could
in the
have fixed it
complaint.
later. You didn't allege that in the complaint.
Okay, so in the complaint, they just said, all this was done before the settlement agreement.
All was done before the settlement agreement, but he says the lease went on a few months more, and they could have fixed it afterwards. Imagine an auto accident where you have a settlement agreement, and then you say just a simple matter of damage to my car, and I damaged your car, so I'm going to pay you $5,000 as a settlement for that. And you say, okay, I'll take that. And then later you say, well, you still didn't fix my car. You could have fixed it later.
Well, but there's a lease here, there's a little difference between a car accident, there's a
Say there-
contractual relationship.
Say there was an agreement to paint your house, and the painter had until Christmas to get your house painted. And in Thanksgiving, you decide, this is a bad paint job, I'll pay you some amount and we'll settle this and we'll walk away. Painter says, okay, that's fine. Homeowner says, okay, they sign a mutual release. And then the homeowner comes back and says, hey, you still didn't paint my house because the contract says you had until Christmas. That's what they're arguing here. You can't fire your old attorney, hire a new attorney because you don't like the terms of a release and file a new lawsuit. It's that simple. They have admitted the damages occurred before the release. The money that they're seeking was received before the lease, before the release was signed. If you say that that isn't enough to bar this claim, the law of releases of Ohio is don't. It's just that simple. Turning to our appeal, there is a rather tortured history on the issue of attorney fees. The entry from Judge Weiss dismissing the complaint was on May 19th. On June 2nd, well within the appropriate time limits, we filed a motion for award of attorney fees. June 17th, 5 days later, they filed their notice of appeal of the dismissal of the case. On July 25th, the trial court called us together before that and said, give us some briefing on this issue of whether I still have jurisdiction to consider an award of attorney fees. So we briefed that, had some discussions with the judge. And on July 25th, the judge put on an order saying, yes, I do have jurisdiction to consider this issue and set it for a hearing. The hearing got postponed by a week or two because of some scheduling things, but then the hearing was held on September 1st. Testimony presented, the normal kind of things that you would present in a hearing on attorney fees. We had in the interim time filed a motion to dismiss their appeal on the grounds that it was premature because until the attorney fee issue was resolved, it wasn't right. This court held on September 14th that while denied the motion to dismiss the appeal, sent it back to Judge Wiest and said, yes, you do have authority. You have jurisdiction to consider this. Hold the hearing. Well, because of the timing of that, the hearing had already been held, but the judge hadn't issued his ruling. But then curiously, on October 17th, the judge said, yes, you are entitled to attorney fees under the settlement agreement, but I've lost jurisdiction. 180-degree turn from his own ruling earlier that he had jurisdiction, and completely inconsistent with this court's order sending it back. I just don't have any explanation for how the judge concluded he didn't have jurisdiction when he himself had ruled he had jurisdiction, and this court had said he has jurisdiction. This court cited Appellate Rule 4B, which is right on point. It's the exact situation. Appellate Rule 4B says that if you get a notice of appeal that you might argue is premature, that you do what this court did. You send it back, you hold the case, you stay the appeal proceedings, you send it back, have the hearing on attorney fees. A motion for attorney fees is specifically one of the things called out in Appellate Rule 4B, and you send it back for the hearing. It's exactly what this court did. It was very appropriate for this court to do that. And how the judge concluded after that, a month or so later, that he didn't have jurisdiction, it boggles my mind. I have no idea, because he clearly had jurisdiction. This court said he had jurisdiction. He said he had jurisdiction.
So are you still alleging that it's not a final bill order?
Well, it became an appealable order after the attorney fee hearing was held and resolved, albeit incorrectly, and so it became an appealable order at that point.
Well, there still wasn't any amount in attorney fees.
Well, because, right.
So
Yes,
if we were to rule in your favor, then it's gonna go back and have attorney fees assessed in a specific amount, and then it'll be back up on appeal again.
Yes, and actually, in response to your question, I was thinking about that last night. I believe that a plausible outcome from you would be to say the appeal is dismissed, because there is jurisdiction to consider the attorney fee award, and therefore we need a decision from the trial court on amount, appropriateness, and all that kind of thing before it is a final order. I do believe that is an appropriate outcome. It would kick the can down the road on the other issues, but yeah, so be it. If that's this court's ruling, dismissing the Zanson's appeal as premature until the attorney fee issue is resolved, and then you would have the entire case in front of you for consideration. I would have no problem with that. I think that would be within the law to do that. Turning to the other issue on our appeal, the court found that we were entitled to attorney fees under the settlement agreement. I don't think there's any question about that. Mr. Pederini argues that it's only in a matter to enforce the settlement agreement. Well, we were seeking to enforce the settlement agreement. I don't know how you could argue that any other way. Of course, their complaint wasn't to enforce the settlement agreement, but our action to have the case dismissed was to enforce the settlement agreement. And so Judge Wiest correctly held that we were entitled to attorney fees under the settlement agreement. So I don't think there's any serious question about that. The more interesting question, I think, just as a legal matter, is the frivolous conduct statute. Here, there are several elements of that, too, that we need to consider under 2323.51. First, because of the release, the whole case is based on a flawed premise. And the whole idea of hiring a new attorney to file a lawsuit after you sign a release for things that happened before the release is inappropriate. I think there's just no question about that. Second, and equally important, I think, perhaps more important, is that a hearing was held on the issue of frivolous conduct. It was part and parcel of the attorney fee hearing. And there was only one person who testified at that, Mr. Mockemer. Zanson didn't show up for whatever reason. And so there was no dispute on the testimony that was presented there. What was that testimony? The testimony was that the greenhouses in question are here, the Besancons live right next door. They see these greenhouses every day, they have to when they drive in and out of their driveway. And he testified, they come over into the greenhouses, they walk through them. Mrs. Besancon would come over for exercise to do walking in cold weather where she could walk inside. And their whole complaint is based upon saying they didn't know what had happened in the greenhouses.
Well, counsel, to Judge Carr's earlier point, this is a motion to dismiss, so whether or not they entered into the greenhouses and could have viewed any damages, is that relevant?
No, that's an interesting question, but here's the reason that that's not a bar here. The issue for which the testimony was given was the issue of whether or not the complaint was frivolous. We weren't dealing with whether the complaint should have been dismissed. I agree with what you're saying, that on whether the complaint should be dismissed, you just look at the complaint and other things. The Ohio law actually allows you to consider more than just the face of the complaint. But you assume the facts of the complaint are true, the releases in the record and so on. Only those things are relevant to determining whether or not the complaint is dismissed. At the time of this hearing, the complaint's already been dismissed.
Sure,
And the issue is what's the sanction?
the complaint could not have been dismissed if a counterclaim was pending at the time, correct? I mean,
There was no counterclaim. Our initial response to the case was a motion to dismiss,
motion to dismiss
which was granted.
with the request for attorney's fees within that motion.
Right. And so we are entitled to it here. Once the case is dismissed, now you're entitled to make a record on attorney fees and the frivolous conduct.
But,
And we made that record.
and then the court determined that there was not frivolous conduct, but that there were fees due pursuant to the settlement agreement.
Correct. And our appeal is that the court was wrong in saying that there was not frivolous conduct, because the only testimony there supported, it can only draw one conclusion, that it was frivolous. When they argued, or they asserted in the complaint that they didn't know what had happened in a building that they are living next door to and are visiting frequently. That is undisputed testimony. How can you base a complaint saying, I didn't know what was going on in a building that you are in all the time? If they wanted to to contest that, they should have showed up and testified. They can't do anything after the fact on that. They had their day in court, they chose not to attend, so Mr. Mockemer's testimony on that is undisputed. And Judge Weiss didn't say, well, I don't believe Mr. Mockemer, he just said, I don't think it's frivolous conduct. I don't know how that's not frivolous conduct when you are telling an untruth on the record. I take that seriously. The obligations of Rule 11 and Section 2323.51 says you're not supposed to do that. Taking it to the next step, the next assignment of error that we've labeled is number 3, is the 2323.51 issue as to Mr. Mockemer. What was the basis for suing Mr. Mockemer here? He had no personal obligation, even assuming something about the repairs, the lease, the greenhouses. He wasn't a party to that lease personally. So they had to argue some sort of a pierced corporate veil argument, which they can't do. First of all, if you don't have a valid underlying claim, there's nothing to pierce the corporate veil for. But equally important, if you look at the elements of piercing the corporate veil, look at the third element. Injury or unjust loss resulting to the plaintiff from the control and wrong. So even if you assume Mr. Mockemer exerted the type of control over the corporation that would justify piercing the corporate veil, that didn't cause any harm. And that's the third element of piercing the corporate veil. Mr. Mockemer was sued just to harass Mr. Mockemer. That is one of the reasons that 2323.51 exists, and it was sanctionable conduct to have sued Mr. Mockemer personally, and Judge Weiss should have found accordingly. We would ask this court to reverse on that issue. Thank you.
Thank you, counsel. You have just under 2 minutes.
Thank you, Judge Carr. accident, that doesn't apply because there's a walkway, there's nothing there. Well, then we have this painted house. Well, it was very telling what Mr. Derschel said. You have a settlement agreement and everyone walks away. Well, that's not what happened here. You had a settlement agreement and these parties still had a contract. They still had a lease for many months afterwards, okay? The complaint, the allegations of the complaint are accepted as true. The Besancons did not know of these damages. That's accepted as true at this standard. The interesting part of this, however, is Mr. McNamara's testimony. He did testify, and it's in the record, okay, that not only did the damages occur prior to the settlement, but he admitted, and it's in the record at page 35, lines 3 through 12, and page 34, lines 7 through 15, that the repairs and the damages occurred after the settlement. Mr. McNamara's own words. Again, the complaint is sufficient. It alleges that this wasn't known, that there was fraudulent inducement. That is all in the complaint. It has to be accepted as true. Dismissal of the complaint was wrong and was an error for that basis alone. But then you have, at a hearing that's in the record before this court, Mr. McNamara admitting that after the settlement, there was additional damages and repairs. Clearly, this case should not have been dismissed at this stage. That essentially disposes of all the arguments regarding the attorney fees. As far as piercing the corporate veil, what was alleged is Cedar Lane got all these insurance proceeds. They didn't do anything with the repairs. Mr. McNamara pocketed the money or put it into other entities. So getting a nice judgment of, and again, Mr. McNamara signed the proofs of claim regarding the allegations of how much damages there were. Those were over $1 million, by the way.
And Counsel, I'm going to need you to wrap up as you're over time.
We would ask the court to reverse the court's judgment of dismissal of our complaint, remand the case for further proceedings. Thank you, Your Honor.
Thank you. Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision which will go to all parties of this appeal, as well as posted on the Ohio Supreme Court website. Thank you both.
Thank you.